say first is this. We are a country of the rule of law. And the guiding document is our constitution. And Article 142 of our constitution, Article 136 of our constitution, and Article 259(5)(c) of the constitution. If you read those articles, you come to the inescapable conclusion that presidential elections are supposed to be held on the second Tuesday of August in the 5th year. And my argument then was that when you count the 5th year, you count from the date of the previous elections until you find the 5th year. And we discover that the 5th year runs from the 9th of August, 2026. And it ends on the 8th of August, 2027. Inside it, find the second Tuesday. And that second Tuesday in August will be the 11th of August, 2026, not in the year 2027. The 10th of August, which some have been proposing, including IEBC, to be the date of the elections, falls in the 6th year. So we went to court, asked the court, number one, we presented the petition, and we also asked the court, because we recognize the question of jurisdiction, we asked the court that, can you give us leave so that we present this petition right at the Supreme Court? Ask for leave, permission for the Supreme Court to admit the petition for hearing. And the Supreme Court, in a ruling issued last week, did say this. In fact, two things that are very important. In fact, you don't need leave. You should just have come directly to us. That's option one. Then two, they said, in fact, the question you are raising, that question, we are aware. Now they are guiding us to where the solution is. We are aware of a decision of the High Court that answered it. And this is what, they even tell us what that decision is. That's the case of John Aaron Moore and others was Attorney General. And they say this: whatever date the first elections are held on, this was in 2010. The next election, the first elections were now the 2013 general elections. Whatever date the first elections under the Constitution are held on, the next elections now going forward after the first one must be conducted on the second Tuesday of August of the 5th year from that date. Hence, more importantly, the term for the next president, members of parliament, governors, and members of the county assemblies may be shorter than 5 years as a consequence of the transitional provisions. IEBC's entire response to the petition and the application for leave was premised on one thing, that these people have a 5-year term, and holding the elections next year will interrupt it. The Supreme Court has told us they do not have a 5-year term. That to me is the take home from the ruling of that court. And now what remains is just to actualize it. IEBC, if it is prudent, she will now proceed and say, we are guided by this ruling by the court. You don't have a 5-year term. Your elections are going to be held next year in August. If they are not going to do it, then we are now going to go back to court and tell the court to issue declaratory orders to IEBC to comply with the directions by the court.
Okay.
Really, let me ask you. What did the court say, the Supreme Court, with regards to jurisdiction? Did the Supreme Court consider this application?
The Supreme Court considered the application that was before the Supreme Court was an application for leave to admit the petition. We were asking them for permission. And they told us, in fact, we do not have jurisdiction to give permission for people to come before us. If you want to come, just come. Don't ask for leave.
Okay.
That is what they were saying, that in fact our application to asking for leave, it does not exist. They don't have anywhere they get the powers to grant leave for people to file petitions before them.
So why are you asking for leave?
Because this was a very, what you call, it's a novel issue that we're trying to raise. And we didn't want to chance by just throwing in a petition without understanding the contours.
Okay.
Now we got our response on the question of leave, but also got our response on the question of term limits.
Okay, now, I want to read the three things that this court said. One, they said, we opine and determine as follows. We appreciate that the original jurisdiction of this court rests on election petitions, and that's exclusive. We find that the motion before us seeking leave to admit this petition was filed unprocedurally, more so where the petition has already been filed, so granting leave would be superfluous. I mean, you've already filed it, then you're coming to say, can we file?
Yes.
You've already done it. That's what they said. Number two, they said that this petition was filed purportedly under sections of the Constitution.
163.3.
And if it were true, a petition under those articles which are self-executing, no leave is required to approach this court for any declaration.
Yes.
The applicant is indeed in the said petition as if it was a matter of right, and if so, no leave is required from this court to do so.
Correct.
But number three, in the absence of jurisdiction, we cannot delve into the merits of your application for grant of leave to admit a petition as sought by the applicants.
Yes.
Right? Consequently, the applicant's notice of motion and filed on this particular 24th of April is struck out for want of jurisdiction, which means that the court says, we don't have jurisdiction. Go to there.
No. We don't have jurisdiction to give you leave.
No, okay.
That is the background. Just remember what you've read, the first two. It's all speaking to the question of leave. Yeah.
But they also said they cannot delve into the merits
Because that's not
the
the main
application
petition.
of
Yes.
grant of leave.
Yes.
So they've basically not determined, they've not said whether the elections are...
No. But in coming up, you see what happens is this. The court must have an opportunity to consider what is this we are being asked to grant leave to consider. So they looked at the petition, which is before them. And they're saying these are the issues that are being contested. And in a preliminary way, you can see their preliminary thoughts on these questions. And for me, more importantly, on the substantive question, because IEBC is the one that brought it before the court in their response, that elected officials have a 5-year term. In fact, if you will allow me, Eric, with your kind permission.
Oh, sorry. I'm also,
So I had to read this. This is what IEBC said in their response. A broad, literal, harmonious, and purposive reading of the Constitution denotes that the term of office of all elected officials under Articles 101, 136(2)(a), 181, and 177(1) is 5 years. And they go further to say that if a contrary view is held, it will upset the guaranteed 5-year term in office for elected officials. That's what IBC said. And the Supreme Court has now told us, wait a minute, there is no guaranteed 5-year term after the first elections in our Constitution. Elected officials will invariably not serve for 5 years. That, to me, is the greatest news that came out of that Supreme Court. That, to me, is it. So what remains, if there's prudence, is IBC to say, we've read this ruling. We are guided by it. We can see what the court is saying. We are all going to hold the elections next year, because now there's no longer any guaranteed 5-year term. But barring them doing it, as a petitioner's lawyer, I'm not at liberty to go and seek compelling orders to IBC. We don't even have to wait for the Supreme Court now to hear the main petition.
So here's the thing.
Yes, sorry.
No, I'm just threading through, and I understand what you're saying. But the court has given its its ruling on the matter of the election date, as we have stated. They said, one, that the Article 140 of the Constitution deals with questions of the validity of presidential elections, which, as the learned Chief Justice observed, is a matter within the original jurisdiction of the Supreme Court. The issue presented in this petition is not that of the validity of presidential elections, but on the interpretation of what constitutes a fresh election.
Yes.
Thus, the Chief Justice was right in holding that the Supreme Court has no original jurisdiction to interpret the said provision. The jurisdiction lies in this court by dint of Article 163. That, I think this is now the one that speaks to fresh elections. So therefore, aware that the High Court in 2011 was faced with a similar question and had to determine the date of the 2013 general election, and it did so in John Haron Moore and 3 others versus the AG and 2 others. So the court stated, as we have stated, the election date for the first elections under the Constitution is provided under the 6th schedule and not affected by the provisions of other articles. Whatever the date the first elections are held on, the next election must be conducted on the 2nd Tuesday of August of the 5th year from that date. Hence, the term for president, members of parliament, governors, members of county assemblies may be shorter than 5 years as a consequence of the transitional provision. That agrees with what you said.
Yes.
Considering all that we have stated above, we know, opine, and determine as follows that we appreciate the original jurisdiction of the court of the Constitution in the presidential elections, and guided by the foregoing principles, we found that the notice of motion before seeking leave to admit your petition was filed unprocedurally, right? It was also filed purportedly under Article 163, as read with Article 140, and if it were a true petition under those articles which are self-executing, no leave is required. In absence of jurisdiction, we cannot delve into the merits of application for grant of leave. So, therefore, the applicant's notion of motion dated 23rd April has been struck out for want of jurisdiction, and each party shall bear their costs of application. So as far as your application for leave, that has been struck out, but the court has also pronounced itself on what had already been previously said, which is that the elections happened under the 5th year. So it's not a ruling that is an order. I don't have to explain it.
It's not an order.
Yes, not an order.
It's not an order, but there are findings which they have made that, in a way, restates the law. That is why I was saying, if IBC is prudent, they should read this ruling. They should not wait for us to go back to court to get compelling orders.
Right.
Do it.
Yeah.
I think you ought to do it.
Eric, thank you very much.
Because
you don't leave